Hello, everyone, and welcome to Baker McKenzie's Labor and Employment video chat series, The Employer Rapport. The Employer Rapport is our series of chats focused on hot topics in the workplace. This is where you'll hear quick practical tips from Baker's employment attorneys on today's most pressing issues for employers as we navigate the new normal. Again, my name is Susan Yandy. I'm a partner in our Palo Alto office, and I manage our firm's global employment and labor law practice for North America. Today, I'm joined by my colleagues, Emily Harbison, from our Houston office and Chrissy Katzenstein from our New York office. I'm going to chat with Emily and Chrissy today about using compensation to incentivize employees towards achieving a company's inclusion and diversity goals. This issue has gained a new salience in the last year as companies across the country address the global reckoning on race and privilege. This is a watershed moment for racial and social justice, and many companies are looking to do all that they can to improve the diversity of their employee populations in a compliant way. One way that we hear companies asking about over and over again is, if it comes down to how people are compensated, how do we use that as a way to incentivize our goals? It's been reported that only a small number of large companies have tied executive compensation to goals for hiring and promotion of workers from underrepresented groups. But for many, many years, companies have tied pay to all kinds of business goals like stock price performance and profits. So with more and more companies wondering why not, we explore the issue and questions to consider today. So Chrissy, let's start with you. What sort of frameworks should employers use to think through whether to use incentive comp as a way to encourage employees to achieve the company's I&D goals?
Thanks, Susan. I think there's really three questions that I'm always thinking about when working with clients on this issue in particular. And the first is just around understanding the objectives of the client's I&D program and understanding, are those objectives consistent with the notion of tying compensation to goals? Because it's not always going to be the case that that works for every client. So that's really the threshold issue. And once you get past that, thinking about how are we going to do this in a way that's lawful to ensure that we're not engaging in any sort of discriminatory behavior. And also this question comes up quite a lot. Once we decide to go down this road, how do we manage and collect the data? That's always a big sticking point for a lot of our clients. And really that first threshold question for clients around, is this something we want to do? Are we going to connect our diversity efforts to compensation? We see two real philosophies here. One is those clients who say, if we want to make a difference, we have to connect it to money. And that's a view that we're hearing more and more. And the second is around concerns that if you do make this connection, you're going to be commoditizing diversity and in turn not leading to that long change that you're ultimately hoping to make and really instilling it into the culture of the company. And we've even heard reports that those managers who are most dedicated and vocal about value-based decision-making, they have a lot of concerns around, if we do it this way, this isn't what I think is culturally right, because we're not doing it because it's the right thing to do. We're doing it because it's incented from a monetary perspective. And where we see a lot of clients land is really somewhere in between. They're finding ways that they can indirectly incentivize the behaviors without making that really direct connection between the compensation they're paying their employees and their diversity objectives.
Yeah, exactly. I feel like it's a constant conversation. And you mentioned data right off the bat, which will continue because every time we talk about this topic, it's always comes back to data in some way, shape, or form. So Emily, after the company has defined its threshold policy, then what's next in terms of how they should think about this?
Sure. So if the company has said, okay, we're going to go ahead and consider tying the compensation to behavior, then it has to drill down on what behavior is actually going to be rewarded and how the behavior is going to be measured and how the compensation is going to be provided. So there's many different variations of this, but there's kind of three themes that we've seen. And the first is reward managers for company-wide achievement of stated company goals. So it's, if the company achieves, a certain goal in this space, then all of the managers, regardless of, where they sit, what they are doing personally, will be compensated for that. The second is more directly tie performance on specific areas of the company's stated philosophy to compensation. So you're looking at individual managers' performance and saying, okay, well, how many diverse people do you have on your team? How many diverse people did you interview? Are you involved in employee resource groups, things like that. And then the last one, which is really where we see most companies land, is include performance against the company's I&D philosophy as a metric of performance kind of overall that feeds into ratings on a more general basis that can ultimately impact compensation. And so even with companies that are more, kind of more mature in this space have really landed on that third point in many cases. And, we think that strikes the right balance. It's a visible platform to bring home the importance of I&D in the organization, but it doesn't commoditize the behavior, as Chrissy mentioned. And it also is the least legal risky as well.
Got it. Okay. And because I like to talk about data, again, that adage, I feel like we all need shirts or something, though I will admit I did not come up with it. I think we got this one from some of our colleagues, but what gets measured gets done is nowhere more true than in I&D. However, ensuring that the data that's collected is done lawfully and without creating unreasonable risk for the company and its employees, and ensuring appropriate use of the data are obviously key considerations to developing an I&D program. Those considerations are heightened if employees will be compensated for measuring those I&D results. You're kind of in a whole different ballgame at that point. So Emily, any tips to share with employers regarding data collection considerations?
Yeah, sure. So kind of first things first, at the outset, companies have to identify if the diversity information that's needed to evaluate performance against their I&D goals can be lawfully collected in all jurisdictions. So, it's different in the US versus outside the US. So kind of that's point one, kind of basic where to start. So typically what we see is companies are collecting gender data on a global basis and only race data in the US. So for those collecting race data outside the US, companies have to look at how discrimination and how race even is defined in those countries. And so for companies who are just kind of getting started with this in the I&D space and tying compensation to this or measuring it, it can be very difficult to kind of get your arms around all of that at once. So kind of don't bite off more than what you can chew in terms of ensuring legal compliance. And then the second point is, there can also be an issue with insufficient data. And so oftentimes measuring diversity, you're relying on employees to report, self-identify and report. And if you only have the race of 30% of your employees, for example, but you're making compensation decisions around it, that can be a problem. And then lastly, the company should determine whether it can legally use that diversity information when making employment decisions, including whether or not you can use those factors in making short-term incentive pay decisions. Companies should also consider the legal risk associated with tracking diversity-related metrics. So particularly in the context of documents and materials that are not protected by the attorney-client privilege. So if you have someone in your legal department that's copied, or outside counsel that's copied on correspondence because they're providing legal direction, there's greater flexibility in terms of what can be included in those documents. Likely they'll be privileged, but you want to be sure that you're copying legal as appropriate on those to ensure protection. It's also really important to determine what's actually needed and not collect more than what's necessary. So for example, if you can get away with collecting, data that's not tied to specific individuals, it's anonymized, then that would be, the best, but you just have to figure out what you need in order to meet the goals. In this case, more is not always better. And then also, it's important to figure out who is going to have access to the data. So we recommend limiting access to individuals at the company on a need-to-know basis, and those individuals who understand the context of collecting and maintaining privilege. And so it kind of leads to another philosophical discussion around who has access to the diversity data in an organization. It runs the gamut from employees or from companies who have just a very small subset of folks internally that tightly hold the information within legal and HR, and those companies who allow for a greater dissemination throughout the company or throughout HR. And then also, we even have companies who are just publicizing it. There is no restriction on who has it. So of course, that employee information in terms of race or gender or other protected classes should be stored outside of an employee's personnel file. And then one final note here, you want to avoid, particularly in those documents that are not going to be protected by the attorney-client privilege, discussing diversity data or metrics or decisions in a way that suggests that the company has done something wrong. So for example, you don't want to include in documents, oh, it looks like we didn't promote enough women this past cycle. There's a different way to phrase that where it makes it sound like the company has an opportunity for improvement and not the fact that they've done something potentially incorrect.
You always need the lawyers because we're helping to reframe the actual intent without creating legal liability, right? I will note that we have a separate video chat on this issue of diversity data collection and management available in the series. If you do are looking at that, are interested in more information. And I'll also note that Emily and others have been working with clients a lot on how to train once you have decided what your philosophy is going to be when it comes to data. And that becomes a very important thing that is a intersection really between legal and HR, and making sure that folks within the organization understand what the data is that they have access to and how to use it. So I'll turn back to Chrissy now. Chrissy, I know you've litigated a number of cases related to I&D issues. Are there any gotchas that companies should be aware of?
Yeah, absolutely. I think the primary concern that we always have with this type of direct connection between comp and I&D initiatives is the potential for a manager to engage in discriminatory behavior when making decisions. So for example, if the goal is to hire X% of female candidates and you will get a bonus of $1,000, for example, there's a natural inclination to start making gender and race-based decisions because there's a financial incentive for the manager. So I think that's always issue number one. To your point, Susan, training is a huge component of this too. So if you're going down this road, that's critical. And the second concern for managers is that this may become a bit of a check the box exercise. So I know that I need to make 10 hiring decisions. I do that. I've fulfilled my diversity obligations. Then they don't really have that true commitment that we're trying to instill through these types of processes. But beyond that, there's also just a couple of gotchas that they can come up in any context, but when you have that direct link to compensation, I think they're more likely. And the first is that things start to be framed as quotas. So you have to have some sort of metric by which to measure a manager to say, did you succeed such that you're entitled to that bonus? And if it's X percentage of your promotions must be women, that starts to sound an awful lot like a quota, which is something we wouldn't recommend because you start to fall on the wrong side of the law pretty quickly there. And so we always have that concern of stay away from quotas, but these types of initiatives can easily start sounding like quotas. We try to reframe that and say it's really about aspirational goals. So we're going to look and we're going to say, based on what we know about the company, the data, the trends, what's realistic for this organization, and we're going to use our best efforts to meet that. But what that means is that we're still making decisions that are gender and race neutral. So the best, most qualified candidate still needs to be the person selected for the role, but we're trying to put diversity in the front of mind too. So we're thinking about it, but we're not making decisions based upon it. And then the other issue that can come up in this context is once we announce that we have a goal, everybody knows that we have some sort of aspirational goal, right? So when we meet the goal, there's always concerns that you may face arguments from the non-protected group that there's actually a preference for the protected group, and that leads to potential race discrimination claims. On the flip side, if you don't meet the goal, you often see arguments in litigation that there's a lack of a true commitment by the company to these types of diversity initiatives, or that there really is something problematic in the way that the protected group is being treated. So there's potential to have it sort of argued both ways, whether you meet the aspirational goal or you don't. That can be problematic for an organization. But at the end of the day, even though there's downsides, you're balancing those against what are the benefits of having a more inclusive and a more diverse workforce. And most of our clients are falling on the side of there's huge value there, and we can manage those downside risks. And a lot of that is about communication. So making sure everybody understands what an aspirational goal is, what it's not, making sure managers are trained, and making sure you have that buy-in from your leadership so that everybody recognizes this truly is a commitment of the organization.
Exactly. I feel like times have changed in a way for the good, in my opinion, where in the old days, this will, I guess, give away how long I've been practicing. The employment lawyers would be like, oh gosh, don't say that, don't do that. And now we're leaning in right there with so many of our clients, and it really is a risk mitigation balancing exercise with the specter of litigation, which, you know, is the scary thing out there for all of us to keep in mind. So thanks again so much, Emily and Chrissy, for sharing your wisdom and your thoughts and your guidance. For our audience, we are here and standing by, ready to help if your company is considering using compensation to incentivize employees towards achieving your I&D goals. Lots of material, lots more video chats that you can access and that will be on the way. So thank you again for joining us, and be well. Take care.